A Social Security disability denial can feel like a judge just stamped your future. It didn't. The notice is a decision about the record SSA had, and the next question is whether the record answered the disability standard. We're not going to promise an approval. We're going to read the path that SSA actually publishes.
Start with the exact reason. A denial notice may point to medical or non-medical issues, and those are not the same problem. The fix isn't to send every document you own. It's to identify the missing link in the decision record.
So the first move is triage, not panic?
Exactly. SSA says each person filing a disability claim is responsible for medical evidence showing the impairment and how severe it's. That does not mean a diagnosis alone settles the claim. The evidence has to speak to the disability question in the notice.
And reconsideration is a new review of the decision and the original application. That's different from silently waiting for the same letter to change.
The clock is the part people can't afford to misread.
SSA's current reconsideration page says to submit a disability or non-medical reconsideration request within 60 days after receiving the decision. If your notice is in hand, put that date on a calendar today, then verify your exact situation with SSA.
Next, we separate the evidence gap from the paperwork path.
Jasmine, what does a useful first read of the notice look like?
Read it once for the headline, then again with a pencil. Circle the stated reason, the date, and every phrase that describes what SSA says the record didn't establish. Don't start by arguing with the whole letter. Start by translating one sentence into one question. What fact would have to be clearer for this decision to be different? That question keeps the appeal from becoming a document dump. It also keeps us honest, because an appeal is a review of evidence and rules, not a guaranteed second chance with a different answer.
And if the notice is unclear, call SSA or get qualified help. A general video can't decide whether a specific notice is medical, non-medical, late, or subject to an exception.
That's the handoff. Notice first, evidence second, official appeal route third. In the next scene, we will put the evidence bridge on the desk.
The emotional trap is treating the word denied as if it described the person. It describes a determination. The useful response isn't to argue with the word in the abstract. It's to ask what evidence or rule produced it, whether the notice is current, and which appeal level is available. That keeps the conversation factual and gives the viewer a place to begin.
A good first read also protects privacy. You can write the evidence categories without publishing the underlying records. Treatment date, testing, functional limitation, and the notice sentence it answers. Keep names, account numbers, and medical details in the secure channel SSA or your qualified helper tells you to use. Kai, write this down as the first filter. Is the problem that SSA didn't find the impairment, didn't find enough severity, or didn't have the right non-medical information? Those questions lead to different conversations. Erica, the viewer, should also know that a generic list of symptoms isn't a substitute for the notice. The notice is the starting document because it tells you what decision was actually made. Once that's clear, the next scene can turn a stressful pile of records into a smaller, more useful evidence map. Let me pause for just a second, because this genuinely helps. If you are getting value here, hit that like button, then subscribe and ring the bell. It costs you nothing, and it is the single biggest thing that keeps these videos coming. Professor Osei, if a denial notice says the record didn't establish disability, where should a person look before adding another stack of papers?
Look for the bridge between the condition and the work-related limitation. The notice tells you what SSA decided. The medical record has to show the impairment and its severity. A new document is useful only if it answers that gap clearly.
Paperwork isn't evidence just because it's tall.
Right. Build a short evidence map. The notice's reason, the limitation it questions, the treatment or testing that speaks to it, and what is new since the original review. Keep the claim anchored to documents, not a comment section diagnosis.
SSA's published evidence guidance is explicit that the claimant is responsible for medical evidence showing the impairment and how severe it's. That's why a provider note should describe relevant limitations when appropriate, not merely repeat a condition name.
Then use the official route. Form SSA-561 is the request for reconsideration. SSA's form page says a medical reconsideration may also require Form SSA-561, the authorization to disclose information.
That page is the useful receipt. SSA-561 names the reconsideration request, and SSA tells you where to send it if you don't use the online appeal. Wait until the end for the 5-item file check.
Don't confuse the form with the verdict. It starts the review. SSA decides the claim.
And keep the confirmation. A clean paper trail is part of protecting the deadline.
K, give me the efficient version without turning it into a shortcut. What belongs in the folder?
The notice, the receipt date, the exact limitation question. Then the smallest set of records that answers it, treatment notes, testing, provider explanations, and a plain description of what the limitation changes in daily or work activity. Label each item by the question it answers. That saves time later and makes the gap visible.
That label is useful, but it must remain truthful. A record can support a question without proving the entire claim. The reviewer still considers the complete file, and the claimant should not edit a provider's meaning into a stronger conclusion.
Exactly. The evidence bridge is a map, not a magic phrase. It helps a reviewer see why the new material belongs in the reconsideration record.
Think of the reviewer opening the file without your conversation beside it. Can that person tell what the notice questioned, what the new page says, and why the page belongs? If yes, the record is easier to follow. If no, add an explanation or ask for help before you file. That's a small writing task with a real payoff. It keeps the appeal focused on the determination instead of making the reviewer search through unrelated material. And the form is the doorway, not the destination. The official SSA page is where we confirm the current instructions before filing.
So the efficient order isn't ICE, question, record, filing, confirmation, 5 nouns, no mystery language required.
And when the evidence does not exist yet, say that plainly. The next step may be requesting records, asking a provider a focused question, or asking SSA how to submit additional material. It's better to name an unfinished record than to decorate it with unsupported certainty.
One caution before we leave the stage: don't rewrite a medical record in your own words and present that rewrite as a provider's conclusion. Attach the record, explain the question it addresses, and let the agency evaluate it. A careful appeal isn't louder than the original claim. It's clearer about the evidence, the limitation, and the procedural request. That distinction protects the claimant from overstating a fact and protects the reviewer from having to guess why a new page was included.
That's the difference between a folder and a case record. The folder holds pages. The case record explains why each page belongs.
Here is the practical version. Protect the clock, explain the gap, and keep proof of what you sent.
First, save the denial notice and write down when you received it. The reconsideration deadline is generally 60 days, so don't let an unopened letter become an accidental calendar system.
Second, make the evidence list specific. What limitation did the notice question? Which treatment record, test, or provider statement addresses it? What changed since the initial review? If none of those questions has an answer, more paper may not improve the record.
Short list, higher signal.
Third, file through the official SSA process. The reconsideration page offers an online disability request, and the form page identifies SSA-561 for people who don't appeal online. Choose the route you can document, and ask SSA what applies if your deadline or notice is unusual.
Fourth, keep a copy of the request, attachments, and confirmation. Don't put medical records or social security numbers in a public comment.
If you're half listening in the car, the one phrase to remember is evidence bridge, notice reason, questioned limitation, supporting record, next action.
A denial is serious. It's not permission to give up, and it's not a promise that an appeal wins. Read the notice, protect the deadline, and use SSA's current instructions.
Erica, one more check. Don't mail the only copy of anything important. Keep the file you can read.
And don't assume a provider, advocate, or internet checklist can see the full SSA record. They can help you organize questions, but the agency's current instructions and your actual notice control the next step.
If the deadline is close, make the call now. If the deadline has passed, explain that immediately and ask what options exist. Don't hide the date because it feels embarrassing. A documented question is more useful than a silent guess. The official page is the place to confirm the route.
The calm version is also the accurate version. A denial tells you what the record didn't establish. Reconsideration asks SSA to look again, and your job is to protect the deadline and present the clearest supported record you can.
Let us make the boundary clear one last time. A reconsideration request isn't a request for a guaranteed favorable result. It asks SSA to review the determination under its process. The strongest preparation is therefore specific and modest. Preserve the notice, identify the reason, gather records that genuinely address that reason, submit through the current official route, and keep the confirmation. If your situation involves a late filing, a non-medical issue, a continuing condition, or a question about representation, ask SSA or a qualified professional instead of forcing your facts into a generic example. The checklist is there to reduce avoidable confusion, not to replace the agency's review.
That's a checklist that earns its keep. It prevents the easy-to-forget steps without pretending to decide the case.
Save that file somewhere you can find it again. Future you shouldn't have to reconstruct a deadline from memory, a sent folder, and 3 browser tabs. A dated note and a confirmation screen are small protections, but they make the next conversation much clearer.
And the file check is 5 things: notice, receipt date, exact reason, evidence that answers the reason, and filing confirmation. If one is missing, that's the first thing to repair.
If you need help, bring that organized list to SSA or a qualified representative. Ask what the current process requires, especially if the notice is old, the deadline is close, or the issue isn't medical. We can teach the map, but we can't inspect your file from a video. Your privacy matters, and so does the difference between general education and case-specific advice. Keep the question focused and the record secure.
No dramatic promise, just a documented next move.
That's the goal of this series. Make the next question easier to ask and the next record easier to protect.
Before the last question, remember, this episode is general education. Your notice and SSA's current instructions control your case.
Like and subscribe for more benefits guidance that turns a confusing notice into a documented next step. Which evidence bridge item comes first? Protect your records, verify the current SSA process, and take care.